registrable and non-registrable trademarks. I take this privilege to welcome the resource person for the day, Dr. Balika Madam, Associate Professor, SDM Law College, Bengaluru. Welcome, ma'am.
Thank you, Rashmi.
Now I request Sriraja, student and member of Navodbhav IPR cell, to introduce the guest.
Good morning, everyone. It's my pleasure to introduce you our guest speaker, Dr. Balika, who has graced us with her presence today to address on registrable and non-registrable trademarks. Our speaker is one with many laurels in her shining armor. A BCom graduate from Besant Women's College, Mangalore University, a Prakrit diploma holder from National Institute of Prakrit Studies and Research, an LLB graduate from SDM Law College, Mangalore University, a master's in international law, and a PhD holder from the prestigious Mysore University. She has a phenomenal teaching experience with the students of both UG and PG courses, expanding to over 25 years, dealing with varied subjects like international law, intellectual property law, human rights law, insurance and banking law, environmental law, contracts law, legal research, and many more. On several occasions in the past, she has served as a member and as a chairperson for the Board of Examination for LLB and LLM. She currently serves as the member of Governing Council body since the year 2018. In her institution, she has been instrumental in serving various leadership roles with the IQAC, Legal Aid, IPR Cell, cultural committees, and many more. She has presented and published many research papers in well-found conferences and journals on various prime aspects of law. She has been part of the organizing committee as well as a keen participant in several national seminars and workshops. She has delivered lectures and talks on various platforms before notable institutions and radio shows. She is currently serving as an associate professor and the vice principal at SDM Law College, Mangalore. Let us all heartily welcome the very renowned Dr. Balika. Over to you.
Thank you. Thank you. Good morning, one and all present here. When I was invited for this talk, it was told that this will be focusing only on the preparation for students for their examination. Keeping that in mind, what needed to be presented, I made an attempt to present it before the students. I'll see to it that I'll do justice to the students when they are participating in this particular lecture. So the topic, of course, I have been given the opportunity of selecting any topic. I considered that any topic is a good topic under intellectual property rights, essential from the point of view of examination preparation, as well as from the point of view of understanding of the subject. But as the students specifically were asking question on this particular question, on this particular area, so I thought I'll take this particular area for discussion for the day. Registrable and non-registrable trademarks. Whenever we think about intellectual property rights, any part of intellectual property rights, any type of intellectual property rights, it starts with an idea. Even when it comes to the questions relating to trademarks or starting up of a business, without an idea, a person cannot start his business. Now, once if he has got a concrete plan as to what business he need to conduct, he must have a name, he must create a brand, he must create a logo, he must create a mark for that, so that it can be in the mind of the public throughout their the existence of this particular business. So the expectation is that once this business commences, this will long last. So whoever who comes to the market must buy my product, must buy this particular product only. So in order to help the consumers to purchase only that product which is sold by me, as a businessman, I must decide, I must plan, and I must, first part, I must have an idea as to what kind of mark I must, or trademark I must create, so that when it comes to goes to the market, any person can easily identify that particular mark. So when we talk about IP for business series, it may be making a mark, the designs of those goods which he or individual is selling or company is selling, or it may be inventions relating to that particular product. So ultimately, your mark, your design, your product, that matters in the market. So whenever we talk about invention, whenever we are talking about selling, we are having a business strategy to sell that product, move that product, give it to the consumers, and let the consumers repeatedly remember. They should not be confused. They should, every time when they come to the market for the purpose of purchasing a particular item, they must think about only this particular product. So marketing and branding becomes an important part. So an idea that has come to the mind of an individual will be considered as a mark if it involves certain things. So what can be a mark? In order to say that, you needed to promote your goods in the market. You may make use of a device, it may be a brand, it may be a heading, it may be label, it may be ticket, it may be name, it may be signature. We have seen word, letter, numeral, shape of goods, packaging, or combination of colors, or any combination thereof. This is the definition which is provided under section 2M of the Indian Trademarks Law, Indian Trademarks Act 1999. So any person who wants to move his product in the market, he will look into that particular mark which will attract the consumers easily. So first time, if he is a first time buyer, he must be attracted by the mark. Afterwards, the product which is sold by this particular company is the best product. So the mark which is used attracts the consumer because this particular product is good. Similar things, similar items are available, or same items are available in the market, but this particular item is the best item which I can buy. This is decided by the consumer by looking into this particular mark. How a mark should be in my product, where I should attach that, what should be the format in which I should provide it. So once again, you can find that there is need for invention, maybe invention relating to your inventing a new word, inventing new designs. It may be with regard to invention of color combinations, or maybe invention relating to new sound, maybe the perfume, fragrance, which is already in existence, which you want to see to it that by the time any person thinks about this particular product, he gets the smell of it. So how individual wants to identify that what should be his mark? How, if it is a mark, whether that mark has got a recognition in the eyes of law. The question, whether there is any need for a trademark, whether there is any need for a trademark. Certainly, the answer is yes. There is a need for trademark. Without a trademark, you cannot move your product or any individual's product in the market today because of the competition that exists in the market. So you can find similar products from varied parts of India, varied parts of the world, all the nook and corner of the world is available, is coming to or rushing into your market, your local markets. So unless you establish your trademark, you cannot survive, or as a trader cannot survive in the field of business. So what is this trademark? Without looking into other definitions, directly we will look into the definition which is provided under the Trademarks Act 1950, of course, Trademarks Act 1999 as amended. Section 2ZB defines it as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of the others, and may include shape of goods, their packaging, and combination of colors. You can find that many things are not there, like inclusion of smell as a mark. Many things are not involved in this or included in this particular definition, because at the time this particular legislation has been brought, they have not thought of new forms in which the trademarks can be created. So you can find limited, but what can be read and what can be accepted, what can be understood out of this as to what is a trademark, we have to analyze. So in order to constitute a trademark, the mark must be distinctive, not a descriptive in respect of its goods and services. It must not be indistinguishable or similar to a mark previously registered or any pending prior application for registration. It must not be prohibited by the Trademarks Act. So mainly we will be looking into these three features as to when we say what is a trademark, what is a good trademark. It must be distinctive, not a descriptive in respect of goods and services. So you can find goods as well as services are included here. And secondly, it must not be indistinguishable or similar to a mark previously registered or any pending prior application for registration. Thirdly, it must not be prohibited by the Trademarks Act. So what are the essentials of a trademark? What are the essentials of a trademark? It is stated that it must be distinctive. Now, all these aspects we will be discussing in detail in the coming slides. First, we will have to list out as to what are the essentials of a trademark. So it must be distinctive. The trademark should be preferably an invented word. It should be easy to pronounce. In case of device mark, the device should be capable of being described by a single word. It must be easy to spell correctly and write legibly. Then it should not be descriptive but may be suggestive of the quality of goods, like A1. Or it should be short, like rin, ben, flex. It should appeal to the eyes as well as to the ear. It should satisfy the requirements of registration. It should not belong to the class of marks prohibited for registration. So you can find, in order to call a mark a trademark as a registrable trademark, as a good trademark, the requirements are these 10. We will analyze each one. Now, the first, as stated, it must be distinctive. Now, when you are talking about distinctiveness in a trademark, the requirement is necessary to the nature of a trademark. So, it is eligible for registration or registrable if it performs the essentials of a trademark function. So what is distinctive is in relation to one class of goods, may not be so in relation to another class of goods. So you cannot have a general statement by saying that because the mark is distinctive, it might not be distinctive in another part or for another goods. as all of us know, with regard to trademarks, categorization is made under the TRIPS agreement itself. There is a mention as to the item-wise classification of marks. It is not that all the marks, all the trademarks are listed out in single line. It is categorized subject-wise. If it is textiles, if it is leather, if it is food items. So categorically identifying that for this particular item, these are the trademarks already registered, or once it is registered in one category, if it is not a well-known trademark, if there is an attempt from the part of any other person to register it as a trademark for any other category, sometimes it is permitted, sometimes it is not permitted, it is subjective. So it is in relation to the class of goods, in relation to another class of goods. So one class of goods and another class of goods. When we are talking about class of goods here, what is that particular goods for which you are selling, for which you are interested in giving trademark. Now, if they are two different class of goods, then in that case, there is a possibility of permission for registration of such mark. But if they are not two different class of goods, then in that case, they are not registrable marks. So at the time of making preparation, or at the time when a person thinks of starting his business, when the idea of business that comes to his mind, he also must think about what trademark, what mark and what trademark he wants to make use of for his products. So when we are talking about distinctiveness in the product, distinctiveness may be inherent or may be acquired. Now, inherent distinctiveness, when we are talking about inherent distinctiveness, the mark or getup is distinct in itself from everything else, and no one can justifiably claim the right to use it. So mark in the shape of an invented word like rin, or it may be the bottle, the shape of the bottle, this inherent distinctiveness which exists. Coca-Cola, whenever you think about Coca-Cola can, Coca-Cola bottle, you can find that the shape of that particular bottle or can is distinctive. So inherent distinctiveness, in that it is imbibed. Acquired distinctiveness. Now, when you are talking about acquired distinctiveness, you can find over a period of time, a particular product is sold with a particular trademark. Because of use of that particular trademark, that particular mark acquires distinctiveness. So through use, when the distinctiveness is acquired, it is a acquired distinctiveness for a long period of time. So you can find that in a product, the distinctiveness, both inherent as well as acquired distinctiveness, is most of the times, in almost all the products you can find, both will be there. But it might be separate, it may be only inherent distinctiveness, or it may be only acquired distinctiveness. But most generally you can find that when the product is inherently distinctive, it acquires distinctiveness. But the moment when it is brought to the market, you can find that there is a need for inherent distinctiveness. Some other person might be using some other mark for the same product. Now, when you are introducing your product in the market, then in that case, you need to come out with a new form of it, so that it can be purchased, it can be demanded in the market. So that the spectrum of distinctiveness, where you can find fanciful marks, arbitrary marks, suggestive marks, descriptive marks, or generic marks. Now, when we are talking about fanciful mark, any trademark which has a coined word, term, which is fanciful and is generally the most easily registrable mark. Arbitrary marks, a mark which is commonly used word but does not have nexus to the goods or services for which it is used is called an arbitrary mark. Apple phone. Apple has got no connection for the phone. Suggestive marks. Mark which is merely suggestive of the goods or services in a remote manner and also requires a certain bit of imagination on the part of the public to discern such nexus is a suggestive mark. So you can find that the mark must be distinctive, but it can be suggestive. Then descriptive marks. A descriptive mark is a mark which describes some characteristics of the goods or services in question. So you can find that this descriptive element could be a quality, it may be quantity, it may be kind, it can be anything. For cleaning product, detergent, clean plus, where it is describing as to what the product is. Then genericized marks. These are marks which were exclusively trademarks and become publici juris, that is generic with the passage of time. Though we know photocopy machines which are called as Xerox or maybe Surf for the detergent powder. So commonly which are used. So fanciful, inherently distinctive Kodak, which is no meaning of its own, but it is fanciful. Arbitrary marks, as we have discussed now, suggestive marks, descriptive marks, generic marks. Now, other than those types of marks, there are other marks which are also recognized. Now, we can find service marks, collective marks, certification trademarks, well-known trademarks. These are the 4 other types of marks. Now, service marks, service of any description. It may be banking sector, insurance sector, which is providing service, boarding, lodging, what maybe restaurants. It can be anything where services are provided. So it is recognized as service marks. We can find the definition of trademarks includes both for goods as well as for the service. So service marks, those categorically identified, you can find that service marks are also included within the term trademarks. Then it is with regard to collective marks. Now collective marks are marks which are identified and promoted by the associations, group of people. Now the people want to sell their products through an association, or maybe today you can find education. If you are looking into company secretary, ICSI, where you can find throughout India with their brand, the company secretary examinations are conducted, or maybe ICWA, or it may be with regard to silk marks. Silk marks, in a way they are certification marks, but because the group of people who are producers of silk products, they come out with that particular mark in order to promote, give guarantee that these are the pure silk products. So you can find association, group of people come out with the collective marks. Certification trademarks. Certification trademarks are trademarks which are, in fact, they are certificates in nature. They are given by the certifying authorities recognized by the government. So you can find it may be ISI, it may be with regard to agromark, depending on the product which is produced, and there is a need for recognizing that particular mark through a certification by saying that this complies the standard. So certification trademarks are to recognize or showing the standard of that particular product. Then it is with regard to well-known trademarks. Well-known trademarks are such trademarks which have acquired a particular status in the market. As I was giving you the example of surf. Now the word surf is a trademark of a particular company. But whenever the word surf is given to the general public, the understanding is that it is a detergent powder. So the trademark has taken the place of a particular product. When the trademark has taken the product of a product, then we can say that such marks are well-known trademarks. There is no compulsion that it must take the place of the trademark. So suppose if we make use of the word Sony, any person when they say the word Sony, you immediately recollect all electronic items. So you can find such words can be considered as well-known. Such marks can be considered as well-known trademarks. Of course, there are certain essential features that need to be looked into when we are analyzing as to what is a well-known trademark. Knowledge or recognition of that trademark in the relevancy of the section of the public who is making use of it, including the knowledge in India obtained as a result of promotions of the trademark, or it may be the duration, the extent and geographical area of any use of that trademark. Thirdly, the duration. Fourthly, the duration and geographical area of any registration, or it may be the record of successful enforcement of the rights in that trademark, or it may be a mark which is determined as well as, or it may be mark which is recognized as a well-known by even one section of the public. Then in that case, we can say that it is recognized as a well-known trademark. So the trademark has been used in India and is recognized by the public, whether it is public in general throughout the world or only in India or only by a particular section of the people who are making use of that variety of product. Then we can call that mark as a well-known trademark. So we can find any product when it carries the word TM, it is a trademark registered, R with the circle, and SM is with regard to service mark. Now there are certain marks which are considered as conventional trademarks. Certain marks are considered as unconventional trademarks. Now these marks will come under the category of unconventional trademarks, like color as a trademark. Internationally, certain companies have recognized color, single color or color combination for their product as a trademark. It may be a sound which is considered as a trademark, shape of goods, packaging, smell as a trademark, holograms as trademark. So you can find two categories: visible signs, non-visible signs, words, letters, numerals, drawings, color, hologram, motion, shape, all these under visible signs. Non-visible signs, sound, smell, these are considered as non-visible signs. So core requirements, you can find distinctive character and non-functional. Then with regard to procedural matters, graphical representation. So register transparency, that is what is required. Now when it comes to graphical representation, Article 2 of the directives must be interpreted as meaning that a trademark may consist of a sign which is not in itself capable of being perceived visually, provided that it can be represented graphically, particularly by means of images, lines or characters, and that the representation is clear, precise, self-contained, easily accessible, intelligible, durable, objective. So it can be anything. So you can find color marks, where any variety of colors, one color or combination of color or multicolors. So you can find that whenever we talk about McDonald's, whether McDonald, the letter yum which is written, or the word McDonald which is written, which is the combination, you can find 5 different combinations. So immediately when you think about McDonald, you get an idea, red base, on that yellow yum and McDonald's written on that. So you can find they are recognizable, even if you are finding that similar words, similar letters are used, similar color, similar combinations are used, but not the same, then you will be in a position to identify these marks. Now, so natural and universal color symbolisms for brands are also used. For example, FedEx. FedEx, F-E-D in F in capital letter, ED in small letter, attached to that E in capital letter, X in capital letter. So you can find FedEx, when it is ground, X color changes. X is in green. When it is flying, it is in orange. So you can find that same bird, when their mode is different, they make use of different color combination. Same company, when they are provide their products, when they are provide services. In case of FedEx, it is a service mark. So in order to constitute a trademark, a color or combination of colors must be capable of distinguishing the goods or services of one trader from those of the other traders. So problem is, if a single color is registered, there are different shades in the same color. So there is a possibility that public may confuse with the shade, or maybe color depletion or anti-dissection. Problems relating to shade confusion, color depletion or anti-dissection will be there. So when we come to sound as mark, it depends on oral perception of the listeners, which may be as fleeting as the sound itself, or if a sound lingers in the mind of the listener and is so inherently different or distinctive that it causes the mind of the listener to be awakened when heard, and the listener subsequently associates a source or event with that sound, then the sound may be eligible for trademark. So when sound can be considered as a mark, which can be used for a trademark. Now, when it comes to graphical representation, there are different modes of graphical representations which are given. So sequence of musical notes, maybe sonograms, audio tape recording, onomatopoeic descriptions, musical notation specifying pitch and duration of sound, electronic application without an attached sound file. So different graphical modes of graphical representation which can be part of the sound, which can be part of your trademark. So roaring of the lion, which is considered as the trademark. So sound marks which are registered in India, there are many more marks now. So 3-note, Yahoo Yodel, ICI's jingle, Alliance sound mark, or it may be Sony, which has planned to use Why This Colaveri as their trademark. Now, when it comes to smell as a trademark, can smell, perfume be considered as a registrable mark? Can it be registered? So, olfactory marks are potentially registrable as they can indicate commercial origin of the goods or services. But in practice, it is very difficult to fulfill the requirements of graphical representation. So as a marketing strategy, manufacturers of the goods introduce a smell of or scents to make the use of the product more pleasant or attractive. So these goods could include cleaning preparations, cosmetics, fabrics, softeners, or maybe even less obvious goods are now manufactured with particular scents to add to the product's appeal. For example, magazines, pens, paper, erasers, etc. So if you are taking the examples for smell as a trademark, you can find smell of rose for tires, smell of a freshly cut grass for tennis balls, or odor of beer for dart flights, smell of plumeria blossoms for yarn, smell of vanilla for office files, cherry scent for synthetic lubricants. So shape as a trademark. It is not only color, smell, but also shape is recognized as, can be recognized as a trademark. So the trademark shall not be registered if it consists exclusively of the shape of the goods, which results from the nature of the goods themselves, the shape of the goods which is necessary to obtain a technical result, the shape of goods which gives substantial value of the goods. Now, other than this, if you are making use of the shape as a trademark, then in that case, in all other cases, shape can be a registrable mark. Shape of the goods, shape of the mark, a shape as a trademark. Shape of the goods, if you are making use of from the nature, or maybe for the technical result, or for if it involves value of the goods, then you cannot include shape as a trademark. Otherwise, shape can be included as a trademark. So you can find varied varieties of bottles. Coca-Cola bottle you can identify anywhere because of the shape it carries, or bank on olive pen loudspeakers. You can find the shape is registered for trademark. Maybe Kit Kat, the way in which it is written, the shape is considered as registrable. So one example, I have borrowed few slides from others. So you would better shape up, says Ukraine's highest commercial court in invalidating Feroz trademark registration for product configuration. Of course, not from with regard to India, but in India, even in India, you can find that as the definition includes, the shape can be a subject matter for registration. So it is a registrable trademark. Even motion trademarks, moving images in the form of a film clip, video, animation, logos, etc., can also be a quality for trademark in some countries. Motion trademark may also be considered even in case of animated marks, moving marks, or movement marks. They are different forms. So even the static image of the Colombian motion trademark is recognized. So in India, we have not recognized such much, but shape is recognized. Shape is registrable mark if it is not in infringement of others, right? If it is not deceiving the marks of others. The arrangement and stages of opening of the doors of a Lamborghini, where you can find design under the design, it is designed in a particular manner. Even the shape of this particular car can be considered as a trademark. So what can be a trademark? Requisites of a trademark. So mark should have a distinctive feature. Mark should be graphically representable. Mark should be capable of distinguishing the goods or services of one trader from those of the others. So conventional set of trademarks contained letters like M for McDonald's, K for Kellogg's, and all. Numerals like 555, 77. So you can find bar soaps. Good number of products which are A1 numbers. Numbers are used over there. Words like apple or any word you can bring in how it is used. Logos where you can find which are graphically represented. So when it is pure orange with the orange color, but with a different shape, maybe half peeled orange is shown for a particular product. It can be a picture. It can be for a symbol. It can be in any form. Of course, most of the times deceptive similarities where the same right mark which is used by the Nike is used reverse, which may lead to deceptive. So symbols are also used as a conventional trademarks. Combination of one or more elements, maybe it is with the word, with the mark, at the same time color combination is there, letters are there, all in one. One particular trademark includes all these features. When it comes to non-conventional or non-traditional trademarks, combination of colors or even a single color in combination with a word or device is considered as a non-conventional or non-traditional mark. Shape of the goods, their packaging, they are not considered as conventional marks. They are non-conventional marks. Sound as a mark, when represented in conventional notion or described in words by being graphically represented, they are not considered as conventional trademarks. So now what are non-registrable marks? A mark by its very nature deceives the public or cause confusion. Now what is deceptive? When it causes confusion. We'll discuss in the future slides. Marks that are contrary to any law. A mark which is likely to hurt religious susceptibility. A mark which contains a scandalous or obscene matter. The shape of the goods which is purely functional or necessary to obtain technical result or which gives substantial value to the goods. The mark that consists of or compromises a name, portrait, or signature identifying a particular living individual. Now, from where we are getting these non-registrable marks or registrable marks? How you can identify the law relating to this? Of course, you have to go into Trademarks Act, Section 9 and Section 11 of the Act, which we will be discussing in detail. But when you are saying that when it is a non-registrable mark in the plain sense, then you can say that these are not registrable. Or chemical names and international non-proprietary names, surnames, personal names, or other common abbreviations are non-registrable. Marks when devoid of distinctive character are not capable of distinguishing. So descriptive marks are not registrable. Generic names are not registrable. Identical or similar marks are non-registrable. So we have seen different types of marks. But whether all marks are capable of registering, capable or are they be registered? Can they be registered under the law, under the registrar? For that question, some cases yes, some cases no. So the mark, when it deceives the public or cause confusion. Now I have borrowed these slides. The examples, if we are taking aquafina or aquafina, for aquafina. So you can find the only one letter change, only one letter change in the word aquafina and aquafina. F-I-N-A, here it is F-E-N-A. So when the first product aquafina is in existence, you cannot go for by making change in one letter, which leads to deceptive similarity. There is a deceptive similarity. When both the products comes to the market, they will cause confusion in the mind of the public whether I have to go for aquafina or aquafina, or a person of less memory, not an ordinary memory, not a brilliant one. A person of a ordinary prudent man will not be in a position to remember when he goes to the market whether it is aquafina or aquafina, or it may be the case with regard to picnic. The word used, the mark used is picnic, P-I-C-N-I-C, and another company which wanted to sell it, which sells its products, P-I-C-N-I-K, where you can find that it is deceptively similar mark. It is not a new mark. It is not a different mark. Of course, one may contend by saying that it is a different mark because there is N-I-K, not N-I-C. But phonetically, both are similar. So when they are phonetically similar, visually similar, they are considered as deceptively similar. Secondly, maybe the case of fexim and fexim. See, phonetically similar. In both the cases, they
Ma'am, you're on mute.
Yes. I'm sorry, because of power cut, something went wrong. Whether the screen can be seen?
Yes, ma'am. Please go ahead.
Hello?
Yes.
Yes. So we can find that when it is phonetically similar, when we are talking about a deceptive similarity, phonetically deceptive similar marks are not registrable. So when you are talking about registration, whether registration of trademarks are compulsory. Okay, first question that comes is whether registration of trademark is compulsory. No, registration of trademark is not compulsory. It is optional under the Indian Trademarks Act. The parties, because even prior to the Trademarks Act, Trade and Merchandise Act 1958, we had common law principle. These marks were recognized as common law marks. Today, you can find after the Trademarks Act, you can find it, they are registrable. The provision for registration and establishment of authorities for the registration of the marks established. So because of which today you can find registration is, this option is available. Earlier, there was no option for registration of the mark. So earlier it was called only as a common law mark. They were not recognized as a trademarks. They are recognized as common law marks. So even today you can find common law marks are recognized. So any person at any part of, in any part of India, any part of the world may go for similar mark, may go for the same mark. Then can it lead, or whether it will lead to, so of course, because there is no registration, there will not be any rejection also. So there will not be any analysis. People will go just and start their business, but they may have to face the consequences of passing off action. But if you are a clever man, if you are a right businessman who thinks of starting a business, then you must look into what kind of mark I can make use of for the purpose of moving my product. So when you are doing that, you are not going to make use of any kind of deceptively similar marks. Then otherwise you need to pay a lot. So how to determine that there is a similarity in the mark? By depending upon the nature of the marks, degree of resemblance, your nature of the mark, what is the product and what is the mark that you have given, depending on the product and what is the mark that you have given. And secondly, degree of resemblance, where, as I was telling you, visually, when you look at the product, how it takes the, an ordinary prudent man considers that this for that. If he considers X for Y, then in that case, it is Y, but it looks like X, the way in which it is formulated. So visual, phonetic, by when you spell that, and idea, with regard to the idea, when it comes to your, when the person intends to buy that particular product, he will not look into other details, but the main detail of that particular product, then it will affect nature, purpose and character of the goods. Nature, purpose and character of the goods. If you are making, see, Lakme, like me, see, when you are using a cosmetics, specifically if you are going for Lakme, today you can find that in the market thousands of varieties of branded products or quality products are available. But originally Lakme was once one product which was considered as a standard product. So the other person who wanted to make use of like me as a, like me with the gap between the two words, or maybe without gap between the two words, like me, like me looks similar. So visually, phonetically, and the product is the same, similar product. And class of purchasers, whether it is affordable to all, who is the class of purchaser, whether the expert in the field is purchasing that particular product or a common man. If it is an expert, even for an expert, as an ordinary prudent man, when he buys, though he is an expert specialized in that particular product, maybe he is a regular buyer of a particular chemical product, but even then, if it is similar, how it is represented, how it is given, based on that you will be in a position to decide whether it is a deceptively similar. Then it is the trade channels here, whether it is online buying, online buying and selling, or offline buying and selling. So if you are making use of a trademark which is offline, you are selling the product offline, Bisleri case relating to Bisleri, you can take as an example, where the same is used for a internet domain name, whether it will lead to similarity, and thereby can it go for registration, can that domain name be accepted? The courts have stated that no, if because the word Bisleri has attained the status of well-known trademark. If it is not, and the product is totally different, and the mode is channel is different, then in that case certainly yes. So we cannot outrightly say that in all the cases it is a similar mark or deceptively similar mark. It is based on these 5 criteria. What is the nature of the mark? Then what is the degree of resemblance visually, phonetically, and in ideas? Fourthly, who are the class of purchasers? Then thirdly, nature, purpose, and character of goods. And fifthly, trade channels which are used for the purpose of selling and buying. Based on that, you can determine that whether that mark is a deceptively similar mark or not. So, use of the word patent or trademark along with the trademark, like patent tax. The word patent tax, general public, that it is a patented one, patent tax. So it is not considered as a good mark. Marks that guarantee, like Vita safe, safety guarantee is given. The word which you are making use of, Vita safe, TM, RPC. So you can find Vita safe product, safe word. Vita is different, but safe, when the word Vita safe is read, safe is the word which is highlighted. So in that case, it gives guarantee about the product. So even that is not acceptable. Then marks containing false or misleading matters, marks which are not strictly true, they are not registrable. Then marks used in illegal business, they are also not registrable marks. Marks suggesting geographical origin. Scotch whiskey is the one. Now if you are using Scotch light, it is geographical, showing geographical origin. That is why it is not considered as a good mark. Mark that consists of or compromise a name, portrait, or signature identifying a particular living individual, except by that individual's written consent. So under the relative grounds, where under section 14 of the Trademarks Act, it allows if the consent is given by the person for using the name as a trademark. Otherwise, name or portrait or signature or identifying any individual or living or dead. In case if he is dead for 20 years, after the death of the person for 20 years, one cannot make use of this particular trademark. So if he makes use of it, is not considered as registrable marks. Then marks when it is likely to hurt the religious susceptibility, because all these are provisions under the Act under section 9, where you can find the absolute ground for refusal of registration. That means that these marks are not registrable marks. Under section 11, relative grounds for refusal of registration, and an exception which is provided under section 12 for honest and concurrent user. Section 13 and 14, where under section 13, under section 14 with regard to name, under section 13 when it is use of a flag or World Health Organization specifically prohibited, such marks are not registrable marks. So the mark when it is likely to hurt the religious susceptibility comes under section 9, absolute ground for rejection of registration. So non-registrable marks. One example, Attukal Bhagavati temple issue. The mark which had a temple deity picture and the title Shabarimala of women as a underclass 42 over temple services, worship services, etc. This was highly contended on the ground that a mark shall not be registered as a trademark as it contains matter likely to hurt the religious susceptibility of the Hindus. The people, the Pope smoked the dope. The Pope smokes the dope. These are the words which are written on the t-shirts. T-shirts sold with this particular trademark, which is considered as religious susceptibility one. Jesus jeans, once again considered as which hurts the religious susceptibility. So if the mark consists of scandalous or obscene matters, what is scandalous? Scandalous means shocking to the sense of propriety, offensive to the conscience or moral feelings, or calling out for condemnation. It may be political imagery, religious terms and icons, or maybe it is affecting a particular race, gender, and or sexual orientation, or it may be containing vulgar words. It may be with regard to illegality. So when we talk about political imagery, portrait and signature, Grover Cleveland for cigars, or Queen Mary on underwear, which is Queen Mary is a political imagery and which cannot be used for underwear. So maybe Obama, Bin Laden, these are the words which are used for the purpose of the products, moving their products, and which are considered as not acceptable. Even religious terms and icons, where you can find messiahs for wines and brandy. They are not considered as registrable marks. There will be a refusal for registration of the mark. You may go without registration, but you will not get a common law remedy in such cases. So race, gender, and sexual orientation. Now, Washington Redskins. So you are identifying a particular racial. You are making a racial discrimination or racial word relating to a particular race of people. So these are not acceptable. Dykes on bikes, or a Deputa Madre, or maybe even the trademarks which are containing vulgar words, bullshit, really good shit. So the word shit is considered as a vulgar here. Illegality, wife beater for clothing was refused on the ground that the term clearly evokes connotation of spousal abuse, and it is considered as scandalous. Then marks contrary to any law. Of course, marks prohibited under the Emblems and Names Prohibition Act 1950, where Names and Emblems Act, where use of seal of UNO, World Health Organization, or use of Indian flag, etc. are prohibited under this. So use of the marks like ISI, ISS are also prohibited under the Indian Standard Institutions Act 1954. Use of BP, IP under the Drugs and Cosmetic Rules Act 1945. So you can find that not only this, the mark should not be signs which consists exclusively of shapes. Now, shape of the goods itself you are giving as a mark, like umbrella for umbrella shape for umbrella is not considered as registrable mark. Shape of the goods which is necessary to obtain technical result, even that cannot be accepted as a registrable one. Shape which gives a substantial value to the goods, even that is also not registrable. In case of chemical names and international non-proprietary names, which cannot be a trademark, pharma research versus jam, where you can find that Olein, O-L-E-I-N, and Olin, O-L-I-N. Olin is a chemical name, and the trademark given is Olin, which is refused for registration. Even Enolar, LOR, where you can find the proprietary name is ADENOLOL, Atenolol, where you can find that analol. In both the cases, the pronunciation phonetically it is analol, but it is a proprietary name of a medicine. So that cannot be given the trademark. Even the surnames, personal names, or other common abbreviations are non-registrable. The word like fantastic sons. Even you can find that the word in Karnataka, Vishnuvardhan's name was registered for a coffee house and coffee products, but it was used with the consent of his wife. After the death of the person, of course, the successors of the person are entitled to give consent for. So in that case, the consent was given. That is why the name of the person, even at the time of his life, Vishnuvardhan himself has given consent for use of his name. One of the fans of Vishnuvardhan used his name for the coffee related products. So if that particular name has acquired a distinctiveness, then in that case, that name can be used. Maybe here the example is Saravana stores, where you can find Manjunatha stores. Everywhere you can find Manjunatha stores. The word Manjunatha has acquired distinctiveness. Because of that, you can go for registration. Marks when devoid of distinctive character, not capable of distinguishing. So maybe laudatory epithets are open to all in the world and cannot be registered. So super, good, etc. These words can never be, they never lose their primary meaning and they cannot be used for the purpose of registration. So name of the article patented cannot be a trademark. Like synoptophone for optical instruments was refused, as it is a special type of optical instrument that has been patented. Marks when they are descriptive of characteristics or qualities of goods or services, like sharp for television, digital for computers, Windows for window software, not permitted. Defenses which are available under this act is, if there is a long-term use of this particular word, then the person goes for registration, then it may be allowed. Large amounts of advertising and publicity with regard to that already has taken place, then also it is allowed. Now, generic names are not registrable. So modem, which has been derived from the word modular, modulator, demodulator, so that is not registrable. Derived from www, World Wide Web. See, this word also not registrable. Hence, we can find that what to avoid, what to register. So when we are going for registration of the trademark, how you can avoid, how you can think of a good trademark which you can register. So it should not be generic terms like chairs to sell the chairs, or descriptive terms like sweet to chocolates, or deceptive terms like wool or pure wool for 100% synthetic material, because it is misguiding. Marks and terms contrary to public order morality, or you should not use flags, armorial bearings, official hallmarks, emblems without a legal authorization. So marks that can't be registered, generic terms, scandalous, immoral, deceptive terms, flags or official hallmarks, descriptive terms, or similar marks, they are not registrable. So what to remember while going for registration of trademark? So you must create, if you are thinking of a trademark, you must create a inherently distinctive mark so that it can easily be registered. Think about fanciful names. There is a need for providing fanciful names so that you can attract the public easily, or mark easy to memorize and pronounce with a positive connotation and that fits the product or image of the business, has no legal restrictions or reasons for rejection. So identify what are the legal restrictions, and there is no reason for rejection of this particular mark. Go for such trademarks. So you search for, so before doing everything, search for existing trademarks and avoid using identical or confusingly similar to existing trademarks. Then suitable for export markets with a corresponding domain name which is not already used. Now, as I was telling you, how we have analyzed here that what are registrable marks, what are not registrable marks. How you can understand, or from where you can get as to what is a registrable mark, what is a not registrable mark, by looking into section 9, section 11, section 12, section 13, section 14 of the Indian Trademarks Act. Trademarks Act 1999, which is in compliance with the TRIPS agreement. Because if you are using, if you are making use of these provisions, if you are looking into these provisions clearly, then in that case you will be in compliance with the international market requirement also. So you can go for registration of a trademark. So under the Act, you can find there are absolute grounds for refusal of registration and relative grounds for refusal of registration. That means that if a mark is not in compliance with the requirements, then in that case there is every possibility that you, when you submit your mark for registration, that trademark is not accepted. That mark is not accepted as a registrable mark. So under section 9, there are 3 clauses under which it is clearly stated. We will have a quick look into what is stated in this particular provision, because from the point of examination, when the students are looking into, they must write on section 9, clause 1, 2, 3, section 11, clause subclauses, then section 12, section 13, section 14. They must write all the provisions and they must analyze this. So from that perspective, I thought like last 5 minutes I'll keep for reading of this section. We'll go just quick reading of the section. Section 9 clause 1 says that the trademarks, if it is devoid of any distinctive character, that is to say not capable of distinguishing the goods or services of one person from those of another person, and secondly, which consists exclusively of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or the time of production of the goods or rendering of the services or other characteristics of the goods or services. Thirdly, which consists exclusively of marks or indications which have become customary in the current language or in the bona fide and established practices of the trade. But with regard to this, there are 2 exceptions to this rule. One is with regard to well-known trademarks, and then with regard to collective marks and certification marks. So if the mark is a well-known trademark, then in that case, you cannot go for registration. There will not be any registration of the mark even if it is not a registered trademark. So what is a well-known trademark? In relation to any goods or services means a mark which has become sold to substantial segment of the public which uses such goods or receives such services, that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to the first mentioned goods or services. Now, section 9 clause 2 lays down a mark shall not be registered as a trademark if it is of such a nature as to deceive the public or cause confusion. It contains or comprises of any matter likely to hurt the religious susceptibility of any class or section of the citizen of India. It comprises or contains scandalous or obscene matter. Its use is prohibited under the Emblems and Names Prevention of Improper Use Act 1950. Then section 9 clause 3, which lays down that a mark shall not be registered as a trademark if it consists exclusively of the shape of the goods which results from the nature of the goods themselves, the shape of the goods which is necessary to obtain a technical result, the shape which gives substantial value to the goods. So it is pertinent to note that the shape of the goods per se is registrable. However, such shape cannot be the very nature of the goods, or the shape becomes mandatory to attain a technical result or give some value to it. Now, other than the absolute grounds for refusal of registration, where we have relative grounds for refusal of registration under section 11. Section 11 says that trademark shall not be registered if, because of its identity with an earlier trademark and similarity of goods services covered by the trademark, or its similarity to an earlier trademark and the identity or similarity of the goods or services covered by the trademark there exists a likelihood of confusion on the part of the public, which includes the likelihood of occasion with the earlier trademark. So you must see to it that when the relative ground is taken as a defense for rejection, then an exception which is available in this case is section 12, which deals with the honest and concurrent users of the trademark. If a person is a honest and concurrent user, that means that without the knowledge, it is subjective. Once again, permission that can be granted with the consent of the registrar for use of the same mark or similar mark in 2 or more places. But with regard to honest and concurrent users, even without the permission of the registrar, here a person has started his registered trademark in one place, and in another place another person at the same time goes for registration and registers the trademark, and their business is limited to their region, then it is expanded, or it might not be, or from the beginning it is expanded business, but both of them making use of this particular trademark without the knowledge of each other about the use of the same mark, then in that case they are considered as honest concurrent users. They are permitted to make use of. So 2 persons can make use of the same trademark if the person is a honest and concurrent user, as provided under section 12 of the Act. Section 11 clause 2 lays down a trademark which is identical or with similar to an earlier trademark, or is to be registered for goods or services which are not similar to those for which the earlier trademark is registered in the name of a different proprietor. Now, this provision deals with the marks which are deceptively similar, identical to an earlier mark, but is used, applied with respect to goods or services totally different from those of the earlier marks. In such case, a subsequent mark will be refused registration only where the earlier mark is well known, and the subsequent mark would be detrimental to the interest of the earlier mark. So under section 11 clause 3, the Act lays down there shall not be the remark shall not be registered if or to the extent that its use in India is liable to be prevented by virtue of any law, in particular the law of passing of protecting an unregistered trademark used in the course of trade. So even under that, under 11.3 relative ground, you can find that if a person is already making use of a particular trademark without registration, even his right is protected under the passing of law. There is common law provisions. And secondly, by virtue of law of copyright, because when the word is used for the purpose of writing, if that is a copyrighted word, if you are making use of that for the purpose of registration of a trademark, then it is a relative ground for refusal of registration. Then section 12 we have seen. Section 13 of the Act, which speaks with regard to prohibition of registration of the marks. Here, with regard to international non-proprietary names, which is the commonly used and accepted name of a single chemical element or any single chemical compound, as distinguished from a mixture in respect of a chemical substance or preparation. We have looked into the examples relating to this earlier. So if it is a chemical, the single chemical name itself is used, and or maybe single chemical compound's name is used for the purpose of product, then also it is not allowed or refused for registration. Then it is declared by the World Health Organization and notified in the prescribed manner by the registrar from time to time. International non-proprietary names which are deceptively similar are not registrable marks. So section 14, which is, as we have already discussed on, the names of the living persons or names of the dead. If the person is already expired, deceased person, then in that case consent need to be taken from their successors. If the person is a living person, if you intend to make use of the name of the person or signature of the person or his identity for as a trademark, then in that case consent need to be taken. Without consent, if you are making an application for registration of the trademark, such trademark is not allowed to be used. So by this we have concluded on the subject registrable and non-registrable marks from the point of view of students and their preparation for the examination. The whole presentation was keeping only in mind It was not to show the intelligence or excellence in the subject knowledge. It was only to give information and understanding of the subject to the students. If you have any questions, please.
Thank you, ma'am.
Yes.
Participants, if you have any questions, please feel free to drop it in the chat box. And we'll wait for a few minutes. If there are no questions, Atulya will take over.
Fine. Hope I have covered all the area that is required for the students, which is useful
Yes,
for the
ma'am, it was
students.
very helpful.
I would like to thank Rashmi, who invited me for this series lecture on the topic. And I'm also thankful to Karnataka KLE College principal and other organizing team of KLE. Thank you.
Ma'am, thank you. There is a question from one of the participants. How can smell be graphically represented? How
That
can
is what?
smell be graphically represented?
Under the Indian Trademarks Act, word smell is not included within the definition of mark or within the definition of trademark. But today you can find that good number of companies are going for registration of these marks. Though this is not graphically represented, it can be retained, it can be recorded. So it is not graphically represented. Only designs are graphically represented. With regard to smell, it can be retained and can be registered. So on the basis of the contention of the states, the industries or sellers of the product who wanted to promote their products through the smell as a trademark, they have gone for registration of the trademark. But under Indian Trademarks Act, there is no word used as smell, because shape is there, shape of the goods is there, color combination is there. That is why the first part we have looked into the definition and then we made an analysis of it. But even smell can be a trademark. Can educational institution and political parties register their trademarks? Educational institutions as service providers, they can register their trademark, but it is a service which they are providing. If it is considered as a business, yes. If it is not considered as a business, if they are charitable institutions, no. But political parties are not, they are not traders. So political parties cannot go for registration. What I stated there is that political names of the political images or the persons who are into the political parties, it cannot be used. Maybe Arun Jaitley's name was used in one of the domain name for when he was a minister for finance for one of the banking sector, online banking sector. They wanted to make use of the name of Arun Jaitley, who was a finance minister at that particular point of time. That is prohibited. So you cannot make use of the names of the persons. In that way, it is prohibited. Political parties cannot go for registration of it because it is not trading. If it comes within the definition of trade or service, it can be registered. Thank you.
Thank you, ma'am. Hope that clarifies the question from Akila. I guess that is it. There are no more questions being raised. Over to you, Atulya.
Thank you, Shreeraja. I would like to take this
procedure
opportunity.
for registration of trademark. You have to confirm that the mark is a registrable mark. You have to apply for, there is an application for
Ma'am, we couldn't hear you. Your connection was cut short. You were saying something about application for registration. Yes.
Okay. Registration, it takes another 15 minutes. So I think we can have a separate session for that. But mainly you have to apply with the Chennai office, because we have main 4 offices for registration of patent and trademark. For trademark registration, we have to go apply for Chennai office, and proceed form is there. You have to fill the form and you have to provide your marks along with that. That much I can tell you now. Thank you.
Thank you, ma'am. I would like to take this opportunity to extend my vote of thanks to a number of people on the completion of the third lecture in the webinar series on IPR. At the outset, I would like to thank and express my gratitude to Dr. Balika. Thank you, ma'am, for taking the time out today and for giving us such a comprehensive lecture on trademarks. I'm sure that the students watching would definitely benefit from the lecture, not only from an examination perspective, but also otherwise. And also, I would like to take this opportunity to thank the student members and the faculties of Navodbhava, the IPR cell, who have put in immense effort to make this webinar series a success. Special thanks to Rashmi ma'am, Simona ma'am, Tanmay sir, and Varun sir for all their valuable inputs. And I would also like to thank Principal Sir for making this event possible, and for our to our academic coordinator, Dr. Anita MJ, and our IQAC coordinator, Dr. Manoj Kumar Hirema. And last but not the least, I would like to thank all the participants who have joined us today, and also take this opportunity to cordially invite all of you to our next webinar, which will be conducted tomorrow at 11 a.m. The topic for the webinar would be infringement of trademarks and remedies against infringement of trademarks. It will be dealt by Ms. Suhasini and Sri Raghavendra, who are IP practitioners. So you'll be getting a practical perspective as well. So this concludes our today's session. Thank you one and all. Have a pleasant day. Thank you.
Thank you, one and all.
Thank you, ma'am.
Thank you, ma'am.